This is docket 22-00613 LT. And will the parties please introduce themselves to the record?
Morning, Your Honor. Brian Lum on behalf of the plaintiff, Max Mather, and Breckenridge Properties. Mr. Mather's sitting to my left.
All right, and I have checked the courtroom. We don't have there's nobody in the Zoom room. And we'll go ahead and make a record of this because I anticipate that we should. This was set for jury trial today, and then second notice was set up based on pleadings that came into the court, articulated pleadings from the defendant and from the plaintiff in this case. And so then we set this for a hearing date today, and we moved the jury trial. And notice was given that you could appear in person or by Zoom to make it easy, to make it the easiest way feasible to come to the hearing. I have the defendant has failed to appear today. So I'm going to place that on the record first. It's now 8:34. This was scheduled for 8:15. So we're past the 15-minute time. Initially, the defendants failed to appear. And then, so this was your motion, Mr. Lum. And then what we did was, as you know, we got it in writing. We articulated pleadings from the responding party, which is Mr. Swift, after last hearing, rather than have him verbalize what the pleadings were. He put it in writing, and now we have it in writing. And so we have your motion in writing. We have him defaulting, failed to appear, so he's defaulted. But it is your motion. So he's defaulted, but I'll let you make a record anyway, and then I'm going to make a record just to cover ourselves.
Thank you, Your Honor.
Okay. So, Mr. Lum, how do you want to proceed?
Your Honor, this is a motion for summary disposition based on MCR 2.116C9, failure to state a valid defense, and MCR 2.116C10, being there's no genuine issue of material fact. Under 2.116C9, the defendant has not made any defense to our notice to quit, being a 30-day notice provided to him in January. He's made some allegation as to a 4-month agreement he had with Mr. Mather's father, who has dementia. He made that in May of 2021. And it's now July now of 2022. He moved back into the property in January of 2022 and has been there for over 6 months. And he has not provided any valid defense to his continued occupancy of the property. He admitted in his pleadings that he received a 30-day notice. And we believe that there's not any triable facts in this matter.
Right. I agree. Once I was able to, I've read your motion. I've also read I've read the plaintiff's response. Rather than have just a verbal response, we have it in writing, and which makes it easy to answer, and which you've done. You've gone through list by list and indicated there was never an oral agreement. Okay? There was never an oral agreement between your current client, and there's no indication that the past client entered into a verbal agreement. There's no lease. With no lease, that makes him a tenancy by at least sufferance, if not month to month. Okay, and 30-day notice was given. There's an indication in his paperwork, in his paragraphs of paperwork, that he should be given 4 months notice. I don't know of any law that would require that, and I thought you brought that out pretty apparently, that there's nothing to indicate that he receives that kind of notice. At the time, he continued to speak about a red tag, the red tag of the apartment, and that's because he moved into a rental that was not code compliant as a rental, and so that's the reason why it was red tagged. It had nothing to do with it was because he was a holdover tenant at the time, and that was why he entered the problem. And there's nothing to articulate about the $5,000 worth of stuff that's mentioned that was abandoned on the premises or stolen. There's nothing but the indication. So I don't see any issue of fact to go to the trier fact. He's actually made admissions in his statement. He actually made admissions about, being a holdover tenant and these things. So I would, regardless of his default today, I was going to rule in favor of your motion, okay, motion for summary disposition. Now we have a default and a motion for summary disposition. And in this matter, based on the failure for Mr. Swift to indicate any possible alleged offense pursuant to his pleadings, which are 2.116C9 and 2.116C10, the pleadings don't indicate any allegation of defense that would take this to jury trial. We would be going to jury trial and he would have no defenses because he doesn't have a legal defense, and that's not why we have jury trials. It's a legal problem. It's not a factual problem. And so I agree that this, so I will grant your motion for summary disposition along with the default because he's not here. And then in anticipation, I will sign any orders. All right. So let's say, so I'm going to have defendant fail to appear. I'm going to say motion for summary judgment granted on default and record made on proofs. Made on proofs of motion. Because I do think avoiding the issue of the summary judgment motion doesn't alleviate you of the responsibility of answering all the allegations. The fact that he didn't show up here means he's defaulted, but it's still a valid motion, and the motion should be granted. So record made in regards to proofs. Anything else for the record, Mr. Lum?
We would just ask in the order that the court confirm that Mr. Swift doesn't have any interest in the property.
Yes. I see of none. So in your motion, you indicate enter a judgment of possession of plaintiff's name, 10 days to vacate, which will be 10 days from the signing of my signing of mine. And then and if you follow whatever order you follow up, I'll take a look at and sign. And I
have an order here.
Okay. And I thought one was presented earlier, but I might already have that order, Mr. Lum.
Okay.
Yeah, I might already have that order. But yes, the ruling, of course, the court talks through its orders. But as soon as I sign that, that'll commence paperwork. I do believe I have both those orders that was indicated.
I have a judgment and
yeah, I had a, but what's that? Yeah, I saw them. I have them. Yeah, but if you have a copy of it, why don't I'll take it, sign it, and give you a signed copy.
I also have a judgment.
All right, perfect. They might be on my desk because I was looking at them, but I'll make sure my staff gets it to you signed. Anything else for the record?
No, Your Honor, thank you.
All right. Thank you, Mr. Lum. Thank you for your patience. Mr. Mather, thank you for your patience. I'm not guaranteeing this is the end of this because we don't know, but this order will start the end of this, okay? All right. Thank you. That's all for the record.